welcome to, what are we? Monday, the 1st of June, pinch and a punch, the first day of the month. Delightful to see you this morning, to have our regulars joining us as well as new people all the time, which is also fantastic. So I'm Bronwyn Pearson, for those who don't know me, Bronwyn Pearson from Pinnacle People Solutions, and welcome to our daily Facebook Live update. This is our 12th week of doing weekday daily Facebook Live updates at 9:15 every weekday morning. So our company provides human resource services and advice, solutions, etc. to regionally based small to medium-sized businesses and not-for-profit organisations, and we are here to help you through these particularly challenging COVID-19 times. As I said, we are live at 9:15 every weekday with updates on new information that's coming every 24 hours, as it has been for the last nearly 3 months, as well as topics relating to staffing and business management. And these are topics that, either, given the nature of what's coming through, we think it's really important for our clients and our audience to know, as regionally based small to medium businesses and not-for-profits, or indeed if it's queries or topic requests that we've had come through our listeners. So don't hesitate to send us some questions and ask us to cover off particular topics. We're very happy to consider that and to put those on the list. So good morning to those who are joining us this morning. Fantastic to see you. So please ask any questions that you may have as we go along. You can just pop them here in the chat screen. If you like, outside of this, you can contact either myself or my phenomenal team anytime via a whole range of different means. Facebook, of course, also email or telephone, website, YouTube, LinkedIn, you name it, you can get hold of us. So those details will be going up in the chat screen, I've no doubt. My wonderful team will pop those up there shortly. And please feel free to use any of those channels to whatever works for you, to reach out to us and have a no obligation free conversation with us about your business and the issues that are challenging you and your business at the moment. So these 9:15 live streams every weekday morning are also recorded, and they're available in Facebook, but they're also available on our YouTube channel, and also in LinkedIn, and also up on our website together with a fact sheet. So each topic that we talk about, there's also an accompanying fact sheet, so that you've got ready information on the matters that we're talking about each day. So first of all, our tendency each weekday live stream is to first talk about breaking news or big changes. And of course, we're a Monday, so I hope you all had a lovely weekend. So the big changes, breaking news that we will be talking about are since Friday, being our last live stream. So we have a relaxation of some restrictions in New South Wales for those of us in New South Wales from today. And those restrictions are designed as part of the three-stage process framework, if you like, that the Prime Minister announced a couple of weeks ago. And it's an intention to help us move towards reopening the economy, but in a COVID-safe way. And we're all being urged to continue to practice, maintain physical distancing and exceptionally good hand hygiene, because it is vital that both businesses and patrons follow health and safety guidelines to ensure we keep people in jobs and businesses in business. So I have done a couple of dive streams in the last 10 days on work health and safety obligations, particularly COVID health and safety obligations. So feel free to go back and have a look at those for information, tips and tricks. We do need to accept as a community and as a business community, as well as a community more generally, that life is different. It's going to continue to be different until we have an effective treatment or vaccine for COVID-19. So we need to be maintaining physical distancing. That's 1.5 meters distance from each other. We need to practice good hygiene. And even if we have the mildest of symptoms, so sore throat, runny nose, get yourself tested. Lots of opportunity now to do that, so please do that. One of the tips that our health experts have been giving us repeatedly is for all of us in any setting that we're in to act as if we're infectious, because it will help us think twice about how we interact around others as restrictions are eased. The other thing to do on the back of that is to treat everybody that you're in contact with or you come into contact with like they have it too. So whether it's you or them, it's important to maintain those restrictions and social distancing, etc. So from today, being the 1st of June, we have a number of things now permissible in New South Wales, which is very exciting. First of all, pubs, clubs, casinos, cafes and restaurants can have up to 50 customers per separate seated food and drink area in their premises. Again, 4 metre square for patrons and everybody in those venues maintaining 1.5 metres distance. We can also travel anywhere in New South Wales for a holiday. We can have up to 50 people attending places of worship and a funeral. We can have up to 20 guests attending a wedding. Zoos, aquariums, reptile parks, etc. are allowed to open from today. Beauty, nail, tanning and waxing salon operators can also begin treatments today. Yippee! Camping grounds and caravan parks can reopen, and museums, galleries and libraries are allowed to open from today also. It is really important to remember, particularly for those who own and run businesses, that in reopening premises or expanding the remit of premises, that you still need to provide 4 square meters per person in your premises. And there's also a requirement for you to have a COVID safe plan in place. And I've mentioned before, Safe Work Australia is the repository for national cabinets, guidelines, principles, support resources, etc. But there's also one on the New South Wales government website, which we'll give you. And the rules on gathering remain the same. So 5 visitors to your own home, still keeping 1.5 metre distance apart, and 10 people outside. Okay, so the changes do mean that that are coming in today do mean that you need, as business owners, to update your coronavirus plan. The effects, obviously, of another lockdown, if that were to happen, would be devastating for businesses across the country. So we need to really be sure to be keeping our workers safe and to plan for a potential outbreak if it happens again. So all of us as business need to develop COVID-19 safety plans and risk assessments in order to reopen or to have employees return to the workplace. And that plan needs to include how a business will handle a further coronavirus outbreak, engage staff in the process, and ensure the final plan is clearly communicated and visible to your staff. So I won't go into the detail now, but we will cover off this week what to include in your coronavirus outbreak plan. But it is really important that you have that in place, particularly if you are looking to reopen or you're looking to introduce more people into your work environment, bring back staff from working remotely, some or all of them, etc. So you need to really ask the questions. Your plan should answer really the following questions. What needs to change to ensure that you can follow guidance swiftly? So we're up here every 24 hours distilling that information for you on what it means for you as employers and employees. So you need to have a plan that means you can change, pivot really quickly on guidance. You need to be clear about what the first step is that you'll take if you're notified of a possible COVID-19 infection. And that could be one of your staff. It could be somebody who's visited your premises. How will you identify if an employee who has contracted coronavirus has been in contact with or nearby your workplace? How will you clearly communicate with your staff if an infection occurs, and what will you say while still meeting privacy obligations? How will you notify the appropriate authorities? Do you have their contact details ready and available in your plan? How will you clean and disinfect your workplace if an infection occurs? How will your business or team continue to operate, trade, or reopen if infection occurs? And how will you notify customers or partners of any business changes if your business must temporarily close? Also, how often will you check in with workers in isolation to ensure their well-being? So that is something you should have already been doing if you've had staff working remotely. And we have previously done topics on staff working remotely. So what you need to be able to do to keep your staff safe from coronavirus, or as far as you possibly can, is to continue to allow staff to work from home where possible. Certainly that is that's the preference of National Cabinet until we get to stage 3. We are only at stage 1. Some states are a little bit ahead of that, but largely across the nation, we're still working through stage 1 and seeing what the consequences of that will be. We need to ensure that we keep physical distancing by a distance of at least 1.5 metres between people. We need to keep encouraging our staff to practice good hand hygiene by frequently washing their hands for at least 20 seconds with soap and water, or by using an alcohol-based hand sanitizer. Being aware of how to spot COVID-19 symptoms, so fever, cough, sore throat, shortness of breath, those sorts of things, and making sure that our staff do not come to work if they're unwell for any reason, COVID symptoms or otherwise, and that they contact their primary health provider to determine when it's safe for them to come back to work. We need to make sure our workplaces are regularly cleaned and disinfected, as in daily. We need to have signs and posters around the workplace to remind staff and others of the risks of COVID-19 and the measures we're taking to try and stop its spread. And we need to have regular contact and communication with our teams and individual staff to provide company updates or changes, to also check in on their well-being and personal circumstances in the event of returning to an office environment, and reiterating the key points that I just mentioned. Those things are important given today's relaxation of some restrictions in New South Wales. The other thing that's been a topic of conversation over the weekend in the media is the looming potential for a minimum wage increase. Now, for the first time, the Australian Industry Group, which is a large employer representative body, has argued, in fact, for the first time in 30 years, that there should be no increase to the minimum wage. The Australian Council of Trade Unions, the ACTU, is suggesting a $30 a week minimum, arguing it would be the most economically efficient and fairest way to drag the country out of recession. The minimum wage case will ultimately affect almost a quarter of the workforce, so more than 2.2 million workers, because of its flow-on effect to award rates. So it's not just the minimum wage, it's the flow-on effect to award rates that it also happens. The government, the federal government, has asked or suggested to the Fair Work Commission that it delay its minimum wage increase this year because of the certainty over the unfolding and unprecedented, obviously, coronavirus crisis. Normally, the review would be finalised this month and is usually updated each year on July 1. And it's determined by an independent panel of experts based on submissions from governments as well as social industry and worker bodies. But the panel has raised the prospect that any rise could be delayed this year, so that certainly is on the cards. I mentioned last week, and this Friday I'll do a deep dive into what we know about the government's planned Job Maker plan. But over the weekend, Industrial Relations Minister and Attorney General Christian Porter said that upcoming sort of discussions through the Job Maker plan on workplace reforms need to focus on the number one game of creating jobs. The idea of the 5 groups that he has set up for this purpose is to look at known problems inside the industrial relations system that are inhibiting the challenge to grow back thousands, hundreds of thousands of jobs, and hear from the parties most affected, each of which have skin in the game, as he says, as to how we may best solve the problem. So they are looking at a collaborative approach between now and September. I'll unpack that more on Friday. In the meantime, There are different views on whether there should be a minimum wage increase on the 1st of July, but we'll keep you notified as to what's happening with that. Okay, so today's topic, somewhat sensibly, I think, in the circumstances, is unfair dismissal and other nasties. And the reason for putting this topic on is not only the volume of inquiries that we've had, but the fact that we know that the Fair Work Commissioner has said that April last year compared to April this year saw a 45% increase in unfair dismissal claims. And these are only due to increase again once we look at May figures, I'm sure, because a lot of people are not happy in respect of how their employers might have handled JobKeeper, JobKeeper enabling directions, and a whole range of other things, which if it leads to termination or constructive dismissal, then you've got the potential for a staff member to take a claim to the Fair Work Commission. So let's just start with some basics in terms of unfair dismissal. And I am going to talk also about general protections disputes this morning, and the concept of adverse action, because that's actually the one that I think is the more risky for organisations, or the thing that would put organisations at a greater risk than unfair dismissal. Not that unfair dismissal is pleasant by any stretch, but let's just look at some of the practicalities around unfair dismissal. So when is a person protected from unfair dismissal? So an employee has to be an employee of a national system employer. So essentially they have to be covered by the Fair Work Act to the National Employment Standards at minimum. They have to have been dismissed, and they're protected from unfair dismissal and eligible to make an application for an unfair dismissal remedy if they've completed the minimum period of employment, which is 6 months, and they earn less than the high income threshold, which for this financial year, bearing in mind it will change on the 1st of July, but for this financial year is $148,700 a year, or a modern award covers their employment, or an enterprise agreement applies to their employment. So that high income threshold isn't relevant if the person is covered by either a modern award or an enterprise agreement. Otherwise, if they're not, they're subject to the high income threshold, and they have to have worked for you for a minimum of 6 months. There is also a time limit for making an application for unfair dismissal. It must be made to the Commissioner within 21 days after the dismissal taking effect. There is flexibility within the Commission to allow a further period of time for lodgement in exceptional circumstances, and I've actually seen that happen quite routinely. So don't necessarily think that you clear after 21 days after somebody's termination becomes effective, because that's not necessarily how it's going to be. So for somebody to apply for unfair dismissal, as I said, they need to have applied to the Commission within 21 days of the dismissal taking effect. So that 21-day period starts the day after the dismissal. In terms of, as I said, a minimum of employment, they have to be employed for at least 6 months before they can apply for unfair dismissal. If you are a small business, and to be a small business, I'll get into the definition of that, but if you are a small business under the Fair Work Act, then your employees in a small business have to be employed for at least 12 months before they could apply for unfair dismissal. If there was a change of business ownership, service with the first employer may count as service with the second employer when counting or calculating the minimum employment period. I did say we are going to do a segment 2 on transfer of business. Very important obligations in there if you're going to buy or sell a business. Small business employers do have different rules for unfair dismissal, and there is actually a small business fair dismissal code, which is available on the Fair Work website, and I'm sure we'll give you a link to that, which provides protection against unfair dismissal claims where the small business employer has followed the code. The Commission will deem a dismissal to be fair if you as the small business employer follow the code and you can provide evidence that you've done so. Evidence meaning everything needs to be in writing. So as a small business, you are defined as any business with fewer than 15 employees. Now, to figure out whether you're a small business and you meet that 15 employee threshold, you need to count all employees employed at the time of the dismissal. Okay, so at the point that you dismiss somebody, you need to have fewer than 15 employees, and you need to include the employee who was dismissed and any other employees that were being dismissed at the time. You need to include regular and systematic casual employees employed by the business at the time of the dismissal. Not all casual employees necessarily, but certainly those who've worked regularly and systematically for you. And you need to include the employees of any associated entities, including those that might be based overseas. The size of the business will be counted at the earliest of when the employee is told their employment's been terminated or when they're given their notice of termination. So either of those two could be an indicator or would be used as an indicator. There are also other forms of dismissal that an employee can apply to the Fair Work Commission if they've been dismissed on the basis of, and that is a breach of general protections, and I'm going to talk about that in a moment. That's one of the other nasties, arguably the largest nasty, or unlawful termination. So we're going to have a look at those in a moment. But before we do, let's deep dive a little bit further into unfair dismissal. So let's look firstly at some useful terms when it comes to a situation where you might terminate the employment of a staff member. You might give dismissal with notice. So this is where you might terminate an employee and give a set notice period in line with the modern award or an enterprise agreement, legislation, or someone's employment contract. You might also pay the person in lieu of notice instead of giving them notice. And you can choose to pay an amount equivalent to the wages and somebody would have received if they'd continued to work through the notice period. There's also summary dismissal. This is where a staff member's behaviour results in serious misconduct that may have an immediate effect on an employer and justifies instant dismissal. And there's also unfair dismissal. And this is where employees who believe the conditions of their dismissal or their termination were unfair, harsh, unlawful, or unreasonable, and they can lodge a claim for unfair dismissal. And in those cases, you as the employer may well need to pay compensation to the employee if the dismissal was found to be unfair. Any termination that you undertake of a staff member needs to be lawful. Let me be really clear about that, and in line with either federal or state legislation. For the purposes of our discussions today, we are talking about the federal system of employment, so under the Fair Work Act and the National Employment Standards. But whenever you're looking to potentially terminate a staff member, it's really important to bear in mind that that termination needs to be lawful and compliant with the necessary employment legislation. Anybody who feels they have been unfairly terminated can take legal action against you or your organisation, and that can be really costly to both your company and the morale and so forth of your team. So as an employer, before you proceed to terminate anybody's employment, you must have a valid reason for that termination. You must make sure that the termination is lawful. I can't stress that enough. I know I have 3 times in the last minute. And you need to make sure that it doesn't breach your employee's employment contract. Also, you need to make sure that the termination also doesn't breach any other kind of legislation that would be associated, such as general protections, which I'll talk about, unfair dismissal, or equal employment opportunity legislation. So things like the Federal Sex Discrimination Act or the Disability Discrimination Act, for example. You also need to make sure that if you're going to terminate a staff member, that you comply with any modern awards, excuse me, or agreements that the employee might be covered by. One of the best ways that you can protect your business is to consider termination issues and include them in the employee's employment contract up front. So this should be something you're thinking about before you bring the next person on board. It's also really beneficial to have clear written policies that cover the expectations that you have as far as your staff's behaviour, and a code of conduct for the workplace, which includes workplace safety, dress codes, harassment, attendance, use of company resources and property, and your organisation's employee termination procedure. All of those things are policies that you should have in place before you look to be terminating anybody. It is also, and I kind of sing from this hymn sheet pretty regularly, I know, but it's really important. It's also incredibly important to have written documentation. The Fair Work Act itself requires employers to provide written notice for termination of employment, which means as the employer, you need to issue a letter to confirm an employee's dismissal, and you need to include a brief summary of reasons as to why the termination occurred. If a termination or dismissal is a result of events or actions, it's best practice to keep records of those on hand as well in case you need to prove the termination was lawful. On top of this, whether your staff member resigns or retires, it is essential that you have written confirmation of this, either through an email or a physical resignation letter. In a case where an employee can't or won't confirm their resignation in writing, you should confirm their resignation or retirement in an employer-issued letter, so you have proof to protect your organisation in any case that might arise with issues down the line. So it's incredibly important to always have in writing a retirement or a resignation from a staff member, even if you confirm in writing that you've received their verbal advice to that effect. You need to make sure that you are taking into account the minimum Fair Work notice periods whenever you make a termination. You must provide a minimum amount of notice in the event of a termination. And the Fair Work notice period is in line with your staff member's period of service in your organisation. And there is up-to-date information on the Fair Work website about notice periods, which we can provide you as well. If there's a case where your staff member's employment contract, their modern award or their enterprise agreement requires you to give more notice than the minimum amount required by Fair Work, you need to adhere to that longer notice period. Notice periods can also vary depending on the type of dismissal and the type of employment contract that somebody might have. So, for example, there is no set notice period for casual employee termination or fixed term or project employee termination unless it says otherwise in the contract or the award. Lastly, if there's no information in your employee's employment contract around notice periods or termination, then reasonable notice needs to be given. This can be vague and it can vary from case to case. So if you're unsure, best to get legal advice or talk to us so that we can make sure that any employee termination that you do is compliant with legislation. Once you have made the decision to terminate, also you have obligations around a staff member's final pay. And some of the questions that can come up with that is, how long does an employer have to pay after the termination has taken effect? Can you withhold pay after termination? When should termination be paid? And how long does an employer have to pay an employee after termination? You need to continue to comply with the Fair Work Act in terms of paying your staff for all work performed, as well as any entitlements that they may be owed, such as annual leave, carers leave, superannuation, etc. All accrued entitlements should also be paid out as per legislation. Usually that's annual leave and long service leave. Most awards, so your staff that are covered by modern awards, most awards will say that employers need to pay employees their final payment within 7 days of the employment ending. If, on the other hand, your staff member resigns without giving the correct amount of notice, you have the right to withhold pay in line with the terms of their award or of their employment contract. In this case, it's best to consult the necessary legislation and get advice to determine exactly what you need to pay your employee after termination. Okay, so according to legislation at both the federal and the state level, although we are only focused today on the federal, you need and must keep records of an employee's employment, their payroll, and their termination for 7 years after the termination was effective. You should also provide your staff with a detailed statement of their termination entitlements. So that's different to a normal payslip. And that should include calculations for each entitlement and any appropriate tax deductions. You would also need to provide a statement of service to that employee if they request it. Bear in mind that in some cases of employee termination, you may also need to notify other external agencies such as Centrelink. That's usually if you are terminating more than 15 staff, or workers' comp insurers. And certainly you would need to let the workers' comp insurers know, because that will potentially vary your payroll for the purposes of determining your premiums. You should also prepare a checklist to ensure that everything is returned by the staff member that is finishing up employment with you. There's plenty of tools out there to assist you with that. We can certainly give you a checklist. In fact, I think there might even be one up on our website actually to help you with that. So when you terminate a staff member for any reason, whether it's poor performance, poor attendance, having a bad attitude, it's absolutely essential to have a clear and detailed policy. I cannot stress that highly enough. Where that doesn't exist, it's incredibly difficult to demonstrate that you followed due process. We can still do that, but it's much more straightforward when you have a policy that you followed. Whether you're firing somebody or you're making them redundant, you must follow the processes stipulated in the Fair Work Act to avoid the success of an unfair dismissal or an unlawful termination claim. This is the only sure way you'll manage the termination process correctly and can be confident that you'll be legally compliant. Look, the reality is that terminating a staff member can be a complex and a stressful process, and may involve dismissal, resignation, redundancy, and it's incredibly important as the employer that you understand your obligations under the employee's employment contract, any modern award that might apply to them, and the Fair Work Act and National Employment Standards as the foundational national system legislation. Because termination is a significant decision that carries quite substantial legal risks, and it can take a period of time, resources, and effort, it's recommended that you get advice if there's anything that you're not sure about. And please talk to us about that. We can certainly help you with that from start to finish. There are really important things that you need to remember if you're going to terminate a staff member. First of all, you need to make sure that the termination is lawful. I know I've mentioned that many times already this morning, but it's incredibly important. It should not breach a contract, equal opportunity discrimination, or any other legislation, and it must be in compliance with any modern award or agreement that covers the staff member. You also need to make sure you've got a valid reason for termination, because if an employee feels the termination was not in accordance with their contract or legislative protections, they can take legal action. They can apply for an order of unfair dismissal, general protections, or they can sue you for breach of contract. It's really important that you are familiar with the provisions of the legislation that cover your staff, or that you have specialist advice and assistance on hand, which we can help you with, to make sure that that knowledge is available to your business. Make sure that the date and the reasons for termination are clear to you, but also to your staff member. Ensure that whoever initiates the termination, whether it's your staff member resigning or retiring, or you, that it's done in writing. Make sure that you comply with notice periods. Provide staff with final payment, including payment of their accrued entitlements. Meet all documentation requirements. So that includes keeping payroll records, providing statements of termination entitlements and calculations, and a statement or a certificate of service. You need to collect any employer property issued before the employee leaves, and that might include things like vehicles, mobile phones, credit cards, business cards, passwords, uniforms, product samples, security cards, any and all of those things. And get things in writing. If somebody resigns or retires, ask them to confirm it in writing. If they can or can't or won't confirm it in writing, issue a letter confirming that you accept the verbal resignation. It must be in writing. If you dismiss an employee, you must issue a letter confirming the dismissal and giving the reasons. It is also best practice if you briefly explain the reasons for the termination. If there were events leading up to the dismissal, potentially also including an investigation, you need to keep records of those as well. So here's some words of advice around employee termination. Don't do the following things. Do not mischaracterize an employee issue. Don't go blindly into making a position, the position of a staff member redundant because you've got performance issues, but you can't be bothered going through the performance review process. Take the attitude the employee is guilty before finalising inquiries. Don't do that. Make sure any investigation you do or any consideration of the issues that might have arisen is seen to be, as well as is, fair and equitable. Do not act in a deceptive manner when advising the staff member to attend a meeting to discuss the allegations. You need to be able to do that openly and transparently with the strictest of confidence between you and the staff member, and you need to invite them to bring a support person with them if they so wish. Okay. There are other than unfair dismissal, there are other protections at work that employees have that are rights at work that are protected, and these include workplace rights. They include taking or not taking part in industrial activities, or belonging or not belonging to an industrial association or a union, and they also have the right to be protected from being discriminated against. Employees, you cannot treat your staff differently or worse because they possess or have exercised a right or for a discriminatory reason. So they're protected from things like adverse action, I'll explain all of these, adverse action, coercion, undue influence or pressure, or misrepresentation. So what are workplace rights? Let's look at those first. So a person has a workplace right if they have a benefit, a role or responsibility under a workplace law. An instrument, an award or an agreement, so say the Fair Work Act or work health and safety legislation, an instrument like a modern award or an enterprise agreement, or an order made by an industrial body like the Fair Work Commission. They have a workplace right if they can start or take part in a process or proceeding under a workplace law or instrument. They can make a complaint or an inquiry about their employment to a body. They also have a workplace right if they are an employee and can make a complaint or inquiry about their employment, e.g. making an inquiry about their pay with you as their employer. They also have the right to belong or not belong to an industrial association, and that would either be a trade union or an employer association. They also have the right to be free from discrimination at work. So employees, therefore, in exercising any of those rights, are protected from adverse action. And adverse action is an action that's unlawful if it's taken for particular reasons. So adverse action includes doing or threatening to do any of the following: firing somebody, injuring the person in their employment, e.g. not giving them legal entitlements such as pay or leave, changing their job to their disadvantage, discriminating between employees, not hiring somebody, offering a potential employee different and unfair terms and conditions for the job compared to other staff, ending a contract or refusing to enter into a contract with an independent contractor, discriminating against them in the terms and conditions offered, altering their position to their detriment, refusing to make use of their services or refusing to supply goods or services to them. An employee or independent contractor taking industrial action against their employer or principal. It's also unlawful for a person to take adverse action against another person for having or using a workplace right, which I've just talked about, belonging or not belonging to a union, taking or not taking part in industrial activity, and having a protected attribute. So let me give an example. Let's say a staff member of yours has lodged a request for assistance with the Fair Work Commission because they don't think they're getting paid correctly. Once you find out about the request, you demote the staff member and change his duties substantially. This is, or could be, irrespective of your reasoning for demoting the staff member and they're changing their duties, this could well be perceived to be adverse action against the staff member because he used his right to ask about his pay. That is unlawful. Coercion is also something else which is unlawful, as well as adverse action. And coercion means forcing someone to do something against their will, for example, through fear, intimidation, or threats. And this has come up a number of times now in queries that we've had associated with employers giving JobKeeper enabling directions and trying to require staff to work more hours than they would normally do in order to get the JobKeeper allowance. So a person can't be forced to use or not use a workplace right. For example, if an employee refuses to vote for an enterprise agreement, you as the employer can't threaten to sack them, threaten to demote them, or change their roster. The coercive behaviour may still be unlawful even if it wasn't successful in forcing someone to do something against their will. So even trying to do it can get you in trouble. There's also, the other thing that's also not lawful is undue influence or pressure. So that's when an employer might use their power to try and influence or pressure an employee to change their conditions of employment. And again, this is coming up a lot of times at the moment. Not exclusively related to JobKeeper, but certainly majority of the queries are related to that. So it is unlawful for us as employers to place undue influence or pressure on an employee to enter into or not enter into an agreement under the National Employment Standards or an award or a registered agreement, agree to or to terminate an individual flexibility agreement, to accept a guarantee of annual earnings, or to agree or not agree to a deduction. And again, the unlawful influence or pressure, just like coercion or just like adverse action, can be unlawful even if it doesn't succeed. So let's give another example. So a staff member is covered by a registered agreement, so an enterprise agreement, which allows for an agreement to be made to cash out annual leave. So this staff member's manager approaches him about cashing out his annual leave. The manager says that because they're a small business, if the staff member takes leave, they would have to close temporarily to cover his absence. The staff member feels obliged to agree with the manager's request. Depending on the way that manager raised the issue with David, this might be considered under undue influence or pressure. However, if the manager made it clear to the staff member that he was in no way obliged to cash out his leave and that the manager was just exploring all possible business options, her request is unlikely to be considered undue influence or pressure. So how you do this is just as important as what you do. This is where going through an appropriate process, having policy that dictates what that process is going to be, and doing it properly becomes really important. It's also unlawful to make a misrepresentation. So that's when you knowingly or recklessly make a false or misleading representation to a person who would expect to be able to rely on you for the advice that you're giving them. Let's say you've got a long-standing casual staff member. She's pregnant with her first child and she asks you about her parental leave entitlement. And you tell her that only full-time employees are entitled to parental leave, even though you know that that's not true. That would obviously constitute a misrepresentation. So there are a lot of nasties for employers that you really need to be really incredibly well aware of. Unfair dismissal is usually the two words that give employees the most collywobbles. But I have to tell you, adverse action, coercion, undue pressure and influence, all of those are far more potentially serious for an organisation than unfair dismissal. The unfair dismissal payments that could be made in compensation if it gets to a tribunal are capped at 6 months' salary. If it goes down a general protections path, those compensation rewards are uncapped. So let me be really clear that this can be really serious for businesses, not just the financial potential consequences of getting it wrong, but also the reputational, particularly if you're a regionally based business. And if you are, then reputation is pretty much everything for you. So the practical realities that I would remind you about in terms of unfair dismissal and these other nasties that we've covered off this morning is make sure you understand your obligations as an employer before you terminate a staff member or threaten to terminate their employment. Get advice, talk to us, put everything in writing. Check all of your employment contracts and put appropriately worded employment contracts in place if they are not either appropriately worded or not in place at all. Incredibly important. Have you got good termination clauses in place in those contracts, including post-employment constraints, return of property, settling debts through termination pay, etc.? If you don't, talk to us. It's incredibly important that you have those things in place. And in fact, I think it was last week, or it might have been the week before, that I did a live stream on employment contracts and position descriptions. Why bother? Very good reasons why you would bother, and go up and have a look at that live stream and the associated fact sheet for more information. Do you have good, relevant policy on performance, conduct, and redundancy? If you don't, you should. I'm going to say again, as I keep singing from this particular hymn sheet also, deal with performance or conduct issues now and do so lawfully and to minimise your risk. The behaviour you walk past is the behaviour you accept. Make sure that you're meeting all of your record-keeping obligations, have robust policy and procedure across the board, and if you're unsure about any or all of the things that I've talked about today, you're unsure about how that might impact your business, please get in touch with us. We'd be very happy to sit and have a no obligation free conversation with you about where things are at for you. So thank you so much again to everybody for joining us today. I'm incredibly appreciative of your participation, suggestions, questions, all of those things. Thank you so much. If you have any particular questions as they might pertain to your business, or you need us or want us to help you out in any way, please contact us anytime. Our contact details are in the chat screen. You can contact us through a myriad of ways. Don't hesitate. So I'd really invite you, warmly invite you all to join us again tomorrow. Our wonderful consultant psychologist, Jessica, is our feature presenter on a Tuesday morning. And tomorrow she's going to be taking us through strategies and tips to understand and address conflict in the workplace. And that's something that we're hearing a lot more about lately as well. So please tune in for that tomorrow. She's going to give some really good strategies around that. So please join us. Please also invite your colleagues and your friends to these live streams. We'd love to see them also. In the meantime, between now and then, please hug the people that you can. Wave cheerily at those that you can't at the moment. Stay safe, stay distant. Please practice social distancing and really, really good hand hygiene, and stay home if you're sick, and we'll look forward to seeing you tomorrow. Thanks so much again for joining us.